One of the big issues within a partnership and between the partners is the agency that exists between the individual partners and the partner's ability to bind a partnership. Now, basically, the way that this works is that when a partner enters into a contract, that partner is entering into a contract that is going to bind all of the partners and the partnership. And so what we have is essentially an agency relationship between the partners. So all of the partners are agents in a sense of each other. They're agents to one another. And so since we're talking about agency, and this is an agency relationship, all of those duties of agency exist here. There is the duty of obedience. Okay? There is the duty of diligence. There is the duty to inform, because what is told to one partner is considered to have been told to all of them. There is a duty to account for the assets of the partnership and all of that. And then there's the fiduciary duty of loyalty. So all of these issues, all of these duties that existed when we were talking about agency, where we were talking not about a partnership, but just somebody who hires an agent, those are all going to exist here as well within the partnership and between all of the partners. So all of those ideas are still valid here. In terms of partners entering into contracts, if it's within the partnership arrangement, a partner is acting as both the principal and the agent when they act on behalf of the partnership. Okay? Any partner individually, usually, unless it's limited somehow, can enter into any contract and binds the partnership. Okay? However, there are some limitations on the ability of an individual partner to bind the partnership that exist automatically as part of the Uniform Partnership Act that are in addition to whatever's in the partnership agreement. Because in the partnership agreement we can say what it is that somebody's able to do. But kind of a general default is no partner can enter into a contract to dispose of the goodwill of the business. Okay? No individual partner is going to be able to do this by themselves or carry out any other act that would make it impossible to carry on the ordinary business of the partnership. And so, how to say this succinctly, can't stop the business of the partnership. Okay, they have to, after a contract, they still have to be able to, the partnership still has to be able to carry on its business. Okay, it's business that it is supposed to do, the ordinary course of the business. Now, one of the issues that we have with agency that still exists here when we're talking about partnerships is the termination of a partner's agency. When a partner is out there acting as a partner, they are in a position to be able to enter into a contract on behalf of the partnership, bind the partnership, and bind the other partners to it. So if the partner is terminated, okay, they're fired, they quit, they leave, whatever the case, we also need to make certain that we terminate the authority of that partner with other people. And so it's just like it is with agency. To existing customers, we need to give actual notice. Okay? Contact them, communicate to them that this person is no longer able to bind the partnership as a whole. For potential customers, all those people that are not existing customers, we need to give them constructive notice. Okay? We need to publish it somehow in a place that's going to be of general usage enough that it's going to be considered to be constructive knowledge to everybody. So this is the same thing as it was with agency, just being applied here to the specific case of partnerships. Now, the partner's liability. Partners can be held liable for the actions that are done by other partners. Okay, a partner signs a contract, and the partnership and the other partners are going to be held to that. Partners are held jointly and severally liable for a contract, for any torts or frauds that are committed by the partnership. They're held jointly and severally liable for liabilities of the partnership and for the contracts that are entered into by the partnership. Jointly and severally means that this other party can sue or try to get one of the partners to perform, or they can get all the partners, okay, jointly, individually, or together. Now, there is an exception to this. If the third party, the other party, knows that the general partner is outside their authority or outside the scope of the apparent authority, the other partners are not going to be held liable if the third party knows. Okay? If the third party knows, then only that party or that partner is going to be held liable. Okay? Only that partner who entered into it inappropriately is going to be held liable. And again, this is similar to agency in terms of the agent doing something that they are not supposed to do. Okay, admitting a new partner. Okay, in the course of a partnership, there's going to be stages. A new partner can be admitted only with the unanimous consent of the other partners. Okay. Now, there's kind of an idea here that's underlying some of this discussion of partnerships, and I'll just introduce it now. What we're talking about here is a small partnership, okay, where there's 3 or 4 partners, 4 or 5 partners, and very likely all of the names of the partners are in the name of the firm, name of the partnership as a whole. There are, as we know, accounting firms and law firms that have thousands of partners located in all parts of the world. There's a separate set of instructions and guidance and laws for that. And these large partnerships can operate much, much more like a corporation than a partnership. And so when some large accounting firm is trying to admit a new partner somewhere, not all of the partners have to agree to that. There's going to be different rules for that. And so kind of as we're talking about this in partnerships, think of it as a local partnership. Okay, 3 or 4 people that have joined a local partnership, and we're not talking about multinationals. They have different issues and a lot of different issues if it's multinational. So we're just looking here at more of a local small partnership. Now, when we have a new partner, it has to be unanimous. The issue that the new partner has is, what are they liable for? What are they going to be liable for? They are not going to be held personally liable for any partnership debts that arose before they became a partner. Okay, so they are not liable for, let's call it, existing debts when they became a partner. Okay, they're not going to be liable for what happened in the past. They are only going to be held liable for what happens in the future and what happens while they were a partner. What happened before they were a partner, they weren't involved. They couldn't vote. They had no impact on that. They had nothing that they could do. So they're not going to be held liable for the things that happened prior to their becoming a partner. Okay, we've got a question here. Under the Uniform Partnership Act, which of the following statements concerning the powers and duties of partners in a general partnership are correct? And what we have to do here is just look at these 2 statements and determine whether or not these 2 statements are true or not. Each partner is an agent of every other partner and acts as both a principal and an agent in any business transaction within the scope of the partnership agreement. Sounds good, especially with this word, within the scope of the partnership agreement. Second, each partner is subject to joint liability on partnership debts and contracts. Yep, that is correct. And so both of these statements are true, which makes choice C the correct answer for us. Okay, our next question. When a partner in a general partnership does not have actual or apparent authority to contract on behalf of the partnership, and the party contracted with is aware of this fact, the partnership will be bound by the contract if the other partners do what? Now, we haven't specifically addressed this, and I left this question in here because it's a good thinking question. What happened is the partner went out, didn't have authority to enter into a contract. The other party knew that. but they did it. They did it anyway. They entered the contract even though this partner didn't have the authority to do it. Can the partnership be bound by that contract? And we talked about this outside the scope of partnership. We talked about this in agency, and the answer was yes. The principal can ratify the contract if they want. And in this case, the partnership, if they choose to ratify the contract, say, yeah, we know the person didn't have the authority to enter into it, but we accept it anyway. If they ratify the contract, then yes, they're going to be bound by that. Amending the partnership agreement, I'm not really sure what that would do. It'd be after the fact, if anything. And so our correct answer here is choice B. If they ratify the contract, then yes, they will be liable for it. They will take that on, just as we talked about with agency and principal, agents and principal. Okay, our last question, which of the following statements are usually correct regarding general partners' liabilities? Again, we've got two statements here, and whether they're true or false. The first statement, all general partners are jointly and severally liable for partnership torts. Yes. Okay, that's the way it is. The second statement, all general partners are liable only for those partnership obligations that they actually authorized. No, the general partners are going to be held liable for all of the partnership obligations authorized by any of the partners. Okay, and so in this it's choice A. Again, just another question dealing about what they're liable for, what they're not liable for, and things like that. Dissolution of the partnership. This is when the partnership, I was going to say falls apart, doesn't fall apart, but somehow is terminated in some ways, dissolved in some way. Now, at a small partner level, dissolution occurs any time a partner leaves the partnership. Okay? Therefore, each partner has the power to dissolve a partnership. They just leave. But the question is whether or not they have the legal right to dissolve the partnership. Is this a rightful dissolution or a wrongful dissolution? And the issue for the individual partner who's leaving is it's going to be a liability question for them because they did it correctly, legally, or they did it outside the scope of that. In a rightful dissolution, if the partnership's leaving does not violate any terms of the partnership agreement, it's a rightful dissolution, and the partner who's leaving incurs no additional liability as a result of their departure. They have the liability for the debts of the partnership up to that point and all of that, but there's no kind of penalty for that. If it's a wrongful dissolution, if they are in violation of the partnership agreement in some way, then they are going to be liable to the other partners for any damages that result from their departure. Now, we have the issue of what are the damages, how do you prove the damages, and things like that. But if the other partners are able to show that they suffered damages, they suffered losses, then this departing partner under a wrongful dissolution is going to be liable for that. Now, there's a number of other ways, other than one of the partners choosing to leave, that a partnership is going to be dissolved. So the first we need to look at are dissolution by operation of law. And what we're looking at here is if-then. If this happens, then the partnership is dissolved. There's no questions. There's no issues about this. If this happens, the law makes it so that the partnership dissolves. The partnership no longer exists. The first of these is the death of a partner. Okay, the death of a partner is going to dissolve the partnership. Okay. The partner's estate who died doesn't become a partner, but that estate is going to be liable for any debts maybe at the time of death. Also, if any of the partners or the partnership is bankrupt. Okay? Bankruptcy of either the partnership or an individual partner dissolves the partnership. And finally, the reason that the partnership was created, the subject matter of the partnership, if it becomes illegal, then the partnership is going to be dissolved. Okay, so these are just, if this happens, the partnership is going to be dissolved. We also have a situation where a court order may dissolve a partnership. And this is going to happen in order to kind of make everything fair. And the situation that we can give as an example here of a court order is that one of the partners doesn't die, but they become physically, mentally incapacitated, and they can't properly function as a partner. They can go to court and ask the partner, or for the partnership to be dissolved. And if this happens, if it's done through court order, this is a rightful dissolution. The partner that kind of asked for the partnership to be dissolved is not going to have any damages connected to a wrongful dissolution. So there may be situations where we appeal, one of the partners appeals to the court for that. A partnership at will is a partnership that is silent about how long it's going to last. So these three people become partners in a partnership, and it doesn't terminate at any one point in time. It's just kind of as long as everybody wants it to. Well, any of the partners can terminate this at any time without incurring any liability. Okay, it doesn't require the other partners to agree. It doesn't require the other creditors. But if it's a partner at will, any partner at any time is able to dissolve it, and it's not going to be a wrongful dissolution. Now, we've got the same issue about notification when we dissolve the partnership as we had when we had this issue about a partner leaving. Unless the partnership is dissolved by operation of law, we need to notify all third parties with whom the partners have had business to stop the apparent authority of the partners or other agents. So when the partnership is dissolved, we still need to notify the existing business, okay, the people that we've already worked with. We need to notify them. And so again, this comes up as just kind of a, you need to remember that when there's an apparent authority, we need to terminate that. We need to stop that. And we do that by giving notice to the people that we have already worked with. Say, the partnership no longer exists, which means these partners can't enter into a contract to make the partnership liable. Okay, they're now operating on their own because there is no partnership anymore. So we still need to remember to make that final step of notification.